Segment 4, what to make of what has gone before. On the one hand, the doctrine of stare decisis, of standing by what has already been decided, precedent. On the other, the originalists' belief that a great many cases in recent decades have been decided incorrectly. Which brings us to this famous remark by G.K. Chesterton that it is the job of progressives to keep on making mistakes and the job of conservatives to keep them from being corrected.
I never heard that.
Had you not heard that one?
No. Who is it, Chesterton?
It's Chesterton.
It sounds like Chesterton.
It's Chesterton.
It's great.
It's Chesterton. Well, that's the bind that a careful, prudent judge would find himself in if he is indeed bound to apply stare decisis. Isn't that the case?
Yes, but I guess some of the mistakes could have been in a conservative direction rather than in a progressive direction.
Do you know that had not occurred to me?
That might happen now and then. But look, you can't. You have to make stare decisis an exception to any philosophy of judicial interpretation. You simply cannot reinvent the wheel in every case. The lawyer's challenging some federal statute, and he comes before the court. Wait. Now, counsel, before we proceed further, are you sure that we have the power to set aside an act of Congress? That's, quite a... And he says, well, Marbury versus... I know, but it might have been wrong. Let's reconsider that. Of course you can't do that. I mean, life is too short. So, by and large, I am not urging that we rip out all of the mistakes made over the last 50 years. One of the mistakes, for example, I think, is the so-called doctrine of incorporation, which has applied against the states the provisions of the Bill of Rights. The Bill of Rights was originally meant to apply only to Congress. It begins, Congress shall make no law.
Yes.
Okay. The theory of incorporation is that the 14th Amendment had the effect of applying that to the states. I think that's probably false. But it's too late. It's been accepted for half a century. I'm not about to tell the people of New York State that their state government is no longer bound by the First Amendment. They'd be held to pay. So, if it was plausible, at least when announced, if it was generally accepted, and if I can work with it as a judge, which is to say as a lawyer, then I'll accept it. If, on the other hand, let's take a fanciful case, Roe versus Wade, if there was no basis for it at the beginning, even those who liked the result acknowledged that the opinion was...
Judge Bork once famously said it contains not a single sentence of legal reasoning.
It's a bad opinion. It was controversial from the outset and remains so. But thirdly, and most importantly, it does not permit me to function as a lawyer. Roe versus...
that is the critical... What do you mean by that?
Roe versus Wade in its new incarnation, which is a case called Casey.
Yes.
Casey, in fact, while saying we will never overrule Roe, overruled Roe. It threw out the trimester system, and the new test of unconstitutionality is whether the state law in question places an undue burden on the woman's right to abortion. All right, that comes before me as a judge. How am I supposed to answer that question? Being a lawyer, I would normally run to the law books and see,
what's an undue burden?
For 2 centuries, no burden was an undue burden. You could prohibit it entirely. So what do you think? How do you think we're going to decide the next case that comes up? Let's say a state law that requires a certain staffing of abortion facilities, so many nurses, so many doctors, expensive equipment, all of which raises the price of abortion. Okay, the claim is this places an undue burden. What do you think we're going to talk about? I guarantee it'll be, doctors, nurses. I don't think it's an undue. You think it's an undue burden? How many think it's an undue burden? It's 5 hands it is, 4 hands it isn't. It's not law. I will not do that. So, by and large, I accept past mistakes, but not those that
Can I-
cast me in the role of. And somebody has to make that call. I don't mean to minimize the importance of somebody making that call, but it's not a lawyer, it's not a judge, it's a legislature that makes those calls.
1966, Miranda versus Arizona, where the Supreme Court announces that police have to,
Right.
in effect, you have to read people what are now
Right.
called the Miranda rights.
I wasn't there then. I've been here a long time,
All right.
but I'm innocent of that one.
You're innocent of that one. But
Yeah.
in the 2000 case, Dickerson versus the United States, the court upheld Miranda, and Chief Justice Rehnquist, no leading proponent of the living Constitution, wrote in the majority decision that the court didn't even have to address the question of whether Miranda was correctly decided in the first place because, quote, the Chief Justice, whom by all accounts you revered, quote, Miranda has become embedded in routine police practice to the point where the warnings have become part of our national culture, close quote. And you wrote a dissent that even by the Scalia standard was blistering. How come?
Well, because the case propagated just a logical inconsistency. It adopted a constitutional rule that you could make an exception from. I mean, we said you can use unmirandized confessions in responding to a defendant's lie on the stand. If he gets on the stand and lies, you can use his confession, even though it wasn't Mirandized. Well, come on, if it's a constitutional violation to use it, you just can't use it for that purpose. So, and anyway, the chief, Rehnquist, was very much a pragmatist. He was not an originalist. He never pretended to be an originalist. Very much a pragmatist.